Good evening, everyone. Honorable dignitaries and esteemed guests, I, Prachi Bhardwaj, on behalf of EBC, feel deeply honored to welcome you all on this momentous occasion where we gather to celebrate the release of the book Mediation in Insolvency, a Game Changer in Viksit Bharat, edited by Justice A.K. Sikri and Mr. Sumant Batra and published by EBC. This remarkable book features contributions from some of the world's leading experts in insolvency and mediation, and it promises to serve as a valuable resource not just for practitioners and students of insolvency policy and practice, but also for anyone involved in the transformation of India's insolvency and dispute resolution ecosystem. To mark this occasion, I would like to extend a warm welcome to the distinguished dignitaries on the dais. It is with great pride that we welcome our chief guest for the evening, whose journey through the corridors of justice has been nothing short of remarkable. Justice Suryakant, who began his illustrious career in Hisar in 1984, has consistently set benchmarks in the legal arena. From becoming the youngest Advocate General of Haryana in 2000 to his elevation as a judge of the Supreme Court in 2019, his trajectory is a testament to unwavering dedication and profound legal acumen, and his impactful judgments underscore his commitment to justice and constitutional values. It is an honor to have you here with us, sir. I would like to request Vaidehi Gulati to felicitate Justice Suryakant. Please join me in welcoming Justice Manmohan, a stalwart in the Indian judiciary whose journey reflects a steadfast commitment to justice and equality. Enrolled as an advocate in 1987 and designated as a senior in 2003, Justice Manmohan's legal prowess quickly propelled him from the bar to the bench. In 2008, he took on the esteemed role of an additional judge of the Delhi High Court, and by 2009, he became a permanent judge, further solidifying his legacy. Now serving as the Chief Justice of the Delhi High Court, his influence continues to resonate throughout the legal landscape. It is an honor to have you here with us, sir. I would request Bhumika Indulia to please felicitate Justice Manmohan. It is with great admiration that we now welcome our next guest of honor, Mr. R. Venkatramani, the Distinguished Attorney General for India. With an impressive 42 years of experience across various legal disciplines, he has consistently proven himself to be a defender of justice and individual rights. His contributions to the legal field not only inspire future generations of lawyers, but also reinforce the vital role that legal professionals play in safeguarding democracy and justice in our society. We are truly privileged to have you here with us, sir. I would request Kriti Kumar to felicitate Mr. Venkatramani. I hope, Vandana, you are fine. Please give a big round of applause. She's a big sport. It is a privilege to welcome our next guest of honor, Mr. Amitabh Kant, the dynamic G20 Sherpa of India. With a distinguished career in the Indian Administrative Services since 1980 and as the former CEO of Niti Aayog and Secretary of the Department of Industrial Policy and Promotion, Mr. Kant has been a driving force behind the transformative initiatives such as Make in India, Startup India, Incredible India, and Kerala, God's Own Country. Mr. Kant's contribution have truly left an indelible mark on the nation's progress. We are privileged to have you here with us, sir. I would like to request Apurva Goyal to felicitate Mr. Kant. Please welcome Justice A.K. Sikri, a trailblazer whose illustrious career has redefined the contours of justice in our nation. With a remarkable career spanning over 4 decades, Justice Sikri has not only shaped the landscape of constitutional law, but has also championed labor rights and arbitration with unparalleled fervor. With over 400 Supreme Court judgments to his name, Justice Sikri stands as a beacon of integrity and a champion of justice. With this groundbreaking book, Justice Sikri, along with Mr. Sumant Batra, is set to transform India's insolvency and dispute resolution ecosystem. We are glad that you found time to collaborate with all the experts from all over the world and give us this book. Thank you, sir. I would like to request Shubhra Venkat to felicitate Justice Sikri. It is now time to welcome Mr. Sumant Batra. With 3 decades of global expertise in insolvency and bankruptcy, Mr. Batra is the only Indian to have been conferred the honor and election as an international fellow by the American College of Bankruptcy. He also holds a distinction of being the youngest and the first president of Insol International from Asia. Beyond his legal prowess, Mr. Batra is the creative force behind initiatives that celebrate India's rich heritage and literature. Together with Justice Sikri, he is poised to revolutionize India's insolvency and dispute resolution ecosystem with this book. Thank you, sir. Again, it is a great deal. I would request Anushka Basu to felicitate Mr. Batra. Founded in 1942 by 2 brothers, EBC has grown from its humble beginnings in law book selling and publishing to India's largest legal publishing house that serves as a vital research source for legal professionals and students. As the director of EBC and associate editor at Supreme Court cases, Mr. Sumit Malik, with his visionary leadership, has propelled the organization to new heights. His strategic insights and innovative approaches have significantly contributed the growth and prominence of EBC. In addition to his role at EBC, Mr. Malik serves as the head of the finance chair at the Entrepreneurs Organization, Uttar Pradesh, showcasing his versatility and unwavering commitment to excellence. I would request Sarisha Chawla to felicitate Mr. Malik. I would now like to request Mr. Sumit Malik to address the August gathering.
My Lord Justice, Surikant. Oh, sorry. My Lord Justice Surikant, My Lord Justice Manmohan, Mr. Venkatramani, Learned Attorney General, Mr. Amitabh Kant, G20 Sherpa, our authors, Justice Sikri, Mr. Sumant, Batra, honorable judges, learned senior advocates, students, and gentle people. It is my privilege and pleasure to welcome all of you to this event where we will be celebrating the release of the book on mediation in insolvency, a game changer in Viksit Bharat. I am grateful to our Chief Justice and the Chief Guest and our guests of honor for taking the time out to participate in this event. I can now safely say that we have now long associations with Justice Sikri and Sumant Batra. This co-authored book is their second with EBC. If you in the audience have attended some of our earlier book releases, you may have heard what I am about to say, but I say it again. In this new world of technology and artificial intelligence, ChatGPT, which allows for instant self-publishing, publishing on blogs, etc., the question is, how do we at EBC see ourselves? What is the role of a publisher? In today's context, I can say that we see ourselves as the trustees of the legacy of authors. We have, over the years, continued to preserve the legacy of authors, names that are synonymous with the study and teaching and practice of law. Professor V.N. Shukla, Professor Kelkar, Dr. Avtar Singh, Professor Ahmed Siddiqui, Shri V.D. Mahajan, Shri V.G. Ramachandran, Professor T.K. Tope, Professor B.M. Gandhi, and others. In addition, it also means the publishing of material on the forefront of legal thought. Mediation as a form of dispute resolution finds its roots even in ancient texts and is deep-rooted in the Indian way of life. Dr. Bibek Debroy, in his chapter, calls it the Dharm Shastra tradition. There is always an elder in the family to whom a family dispute would be referred to, a community elder who is happy to mediate in a dispute between two neighbors. Even formally, many mediation rules have been enacted by states and high courts under provisions of the CPC even before the Mediation Act 2023 was enacted and enforced. To be able to use mediation as a dispute resolution mechanism in insolvency proceedings, some of which could be multi-million-dollar proceedings, would truly be a game changer in Viksit Bharat and help unburden our already overburdened court system. There is very little material available on formal mediation, let alone mediation in insolvency. This work, which is before you, which has insightful chapters from the top names in the world, straddling both the insolvency and mediation world, will be extremely useful to the insolvency practitioner. A book, as I see it, is a custodian of thoughts and ideas, whereas judges, while deciding cases, are bound to decide the list before them on a given set of facts and apply the law to those facts. Authors, when writing books, do not face such limitations. A good author will explain the law to the audience, but a great author, and in this book there are many, will also show the light forward by placing their thoughts and ideas in form of a book and what they consider the law ought to be. The authors who have contributed by writing chapters have done exactly that. As we at EBC enter our 82nd year since incorporation, what we have learned is to understand what the legal profession requires and what our role can be in fulfilling that requirement. We believe that our role is to bridge the gap between legal information and knowledge and those who consume that legal information and knowledge. As a third-generation member of this publishing house, I have been blessed and to be even shown the way by my elders. My granduncle and grandfather had very humble beginnings, delivering books on bicycles to lawyers, including the great Dr. Ambedkar, when they started off as booksellers in 1942. But even then, the mission was clear: provide a service which will assist the practitioner in her work. The mission continued with the same spirit when EBC started publishing books for lawyers and students in 1947. The books we produce must necessarily be of very high quality and assist the user in their quest for knowledge. To be effective in our role, it is important that the materials or content that we produce is authentic, accurate, and reliable. Also, we've continued to innovate over the years to keep ourselves relevant. In 1969, when Mr. Suren Malik graduated from the Delhi University, having studied by the newly introduced case method, he realized that there was a need for faster reporting of Supreme Court judgments. Thus came about the innovation of Supreme Court cases, or SEC as we know it today. As you're all aware, there can be no second edition of a law report, and it must be got right the first time. Prompt, accurate, and complete has been our philosophy, which we have adhered to since then, and we understand and recognize our responsibility that the honorable judges and bar rely on SEC. He has now taken up the onerous task of reporting judgments of the Supreme Court since 1950 till 1968, a period not covered in SEC earlier. In just the first 10 volumes published, we discovered and reported many important judgments of 4 judges and 3 judges that have never been reported before. With High Court cases, HCC, our newly launched venture, we begin the journey to report judgments of the High Courts of India with the same alacrity and comprehensiveness as we report the Supreme Court. EBC has recently welcomed Company Law Institute into its fold and is now offering the famed ITR, company cases, goods and services taxes reporter in both print and electronic form to our subscribers. EBC was amongst the first Indian publishers to introduce a legal research database on CD-ROM in 1996, which was less than 650 MB in size, and now the SEC Online Web Edition has grown to over 20 terabytes of data, 5.4 million documents covering over 300 jurisdictions around the world. Even though we believe that the printed book is not going away, yet for the tech-savvy, EBC's EBC Reader platform is ready and has over 400 books, and we add new ebooks to it every day. SCC Times, a web-based blog on which we report proceedings in court, law schools, and the like, has now over 1 million views and over 500,000 visitors every month. It is being relied on by an increasing number of legal professionals as their source for authentic and analytical legal news. Consistently innovating, EBC's newest service, EBC Learning, an e-learning platform, and Mercury, a judgment tracking software, has already gained loyal users. We are also fortunate to have as part of the EBC family a dedicated team of legal editors, software engineers, DTP staff, proofreaders, sales and marketing staff, and managers who are as much, if not sometimes more, invested in ensuring that what is produced from the house of EBC is of high quality, authentic, accurate, and reliable. This has been a wonderful experience working with Justice Sikri and Mr. Batra on this book. Mr. Batra has already begun revising his book, Corporate Insolvency. He is already one of the foremost authorities on insolvency, and I'm sure that when the work is out, it will be a reflection on how well we have done till now and a guiding light on the way forward. I cannot end without acknowledging, there will be a formal word of thanks, but without acknowledging the efforts of Prachi Bharadwaj, Bhumika Indulia, Nilufar Bhateja, Apurva, Shubhra, Kriti, Anushka from the EBC team, and Vedehi Gulati, Shiv, Shivani, Sarisha, Vandana, and Sandeep from the Insolvency Law Academy team in putting together this event together. Thank you. Jai Hind.
Thank you, sir. I would now like to invite Mr. Batra to address the audience.
Honorable Chief Guest Justice Suryakant Ji, Judge, Supreme Court of India, Shri Justice Manmohan Ji, Chief Justice of Delhi High Court, Shri R. Venkatramani Ji, Attorney General for India, Shri Amitabh Kant Ji, G20 Sherpa, very distinguished guests present in the room, including the authors in this book. On behalf of Justice Sikri, Honorable former Judge of the Supreme Court of India, presently International Judge, Singapore International Commercial Court, the co-editor of this book, I express my deep gratitude to all of those who are present here to share with us this moment of happiness and also a big stride in the way of trying to build a robust insolvency system in the country. When Insolvency Law Academy was conceived in June 2022, it was following a nudge by late Vivek Deb Roy ji, where we were discussing a kind of an update on how the IBC is performing. And he suggested that we should have a first-class research institute on insolvency, which meets global standards, provides cutting-edge research, which can guide policy making and help standard setting in insolvency. The first thing that was done after the institute was set up I met Justice Sikri and requested him to chair the Global Advisory Board of very, very many eminent people, including from the World Bank, IMF, and Insol International, and other streams of insolvency from around the world. And when we sat down to sort of discuss the vision and the agenda for the ILA for the next 5 years to 7 years, at least, one of the things that he suggested, alongside many others, was that we should certainly see how and explore if we can make use of mediation in insolvency. This was alongside other subjects that we were looking at: climate change, building scholarship in insolvency, looking at some other areas where we thought that we can take thought leadership of insolvency around the world. We've come a long way in the last 2.5 years. We have produced a good body of work already, a number of research papers, but this is our first collaborative effort to come out with a publication in partnership with EBC, which we believe will take thought leadership in this area, not just in India, but also beyond. We believe that insolvency law was intended to be, and generally is globally, non-adversarial in nature. Yet, disputes do arise amongst parties, between parties, before or after or during the admission or the process itself. Most of these end up at the doorsteps of NCLT, clogging its board and unfortunately delaying the processes. And we thought that mediation could emerge as one of the possible policy choices, as well as a practice choice, which will enable parties to resolve a lot of issues by use of amicable procedures such as mediation. And that is how the idea of the book came. Because there's no comprehensive literature on this, whether globally or in India. There are, of course, a number of essays, there are a number of research papers, there are a number of thought papers on this subject, but there's no comprehensive single book on mediation. And we thought maybe that's an opportunity for us to take lead in this area, and we decided then to narrow down on who all we should approach for contributing essays. And I'm so delighted, and of course I feel humbled at the same time, to say that we have been able to get support of, and we have them in the shape of essays in the book from the top policymakers in the country, including from the Prime Minister's office. We have honorable former judges of the Supreme Court. We have the insolvency regulator. We have the World Bank. We have the Insol International, which is the global federation of insolvency community fraternity in the world. We have some of the judges from abroad who have great experience in this subject writing. We have American Bankruptcy Institute writing. We have some of the top minds in this country as mediators or as insolvency professionals, as even academics who have contributed. We have 26 essays from some of the top minds around the globe, including, of course, from our own country. And the whole idea is that we should be able to shape the narrative on this subject, and to see how we are able to contribute to make insolvency law more robust going forward by applying mediation as a powerful tool. One of the last things that I want to mention is that you will find in the book, as a last essay, as Arun Jaitley Mediation Center. About 2 years ago, Arun Jaitley Foundation and Insolvency Law Academy collaborated and decided to set up a mediation center which is dedicated to late Arun Jaitley ji, and which is aimed for becoming one of the most sophisticated, topmost global mediation center by the market itself, which will complement the efforts of the policymakers and the institutions that are being set up by the government with the blessing of the government and, of course, with the blessing of the Supreme Court as well, and to see how we can provide a competitive private sector institution which will train, create capacity, and also, in times to come, offer mediation services. So with this, I once again express my deep gratitude to all those who have contributed the essays in the book, and I also express my thanks to the honorable dignitaries who have accepted to launch this book today for us. Thank you so much.
Thank you, Mr. Batra, for that amazing introduction to the book. On that note, before we proceed any further, I would like to request our chief guest, Justice Suryakant, to please release the book for us. I would also like to request all the distinguished dignitaries on the dais and Mr. Surendra Malik, Managing Director, EBC and Chief Editor, Supreme Court Cases, and Mr. Sumant Malik, Director, EBC and CEO and Founder, SEC Online Division, to join us on the stage to commemorate this momentous occasion. What a wonderful sight to behold. Congratulations to all. I would now like to invite Justice Sikri to say a few words on the occasion.
Thank you and good evening to all of you. My two dear brothers sitting on the dais, Justice Suryakant and Justice Manmohan. My two very dear friends sitting on the dais are Attorney General Mr. Venkat Ramani and Mr. Amitabh Kant. Mr. Sumant Batra, very, very dear to me in so many ways. And Mr. Sumit Malik, who is the creator of today's product, if I may say so, along with his team from EBC. All the very, very special persons in the audience, including Mr. Sahu, the first chairperson of IBBI. And what I find in the audience is persons of our own family, as I call mediation family. I think everybody who is sitting in the audience is not only committed to mediation, the cause of mediation, they have been working tirelessly to achieve the miracles and magic of mediation work in this country. So my thanks to everybody who is here in the audience today. As I have mentioned that all of you are so well versed with the mediation, so I don't have to tell you about the magic and miracles of mediation, because as I said, you are producing that magic and you are achieving those miracles day in and day out while resolving so many disputes through mediation every day. But I would only say, as far as the journey of mediation in this country, from 2005, when the first mediation center as a project, pilot project was set up in Tisarari in Delhi, and immediately thereafter in Delhi High Court, and now almost every nook and corner of this country. We have realized that in many ways, mediation is a better form of access to justice, and it's a better form of even arriving at more just resolution of the disputes when compared with other systems. In many ways, when I say under many, many circumstances, it proves to be so. Secondly, it's a good substitute for adversarial system, which normally the courts and arbitration adopt. Again, there are many disputes which are not to be litigated in an adversarial system, and mediation becomes a savior in all those disputes. Number 3, which was the main purpose for which the mediation was introduced in this country after seeing its success in the West and more particularly in United States, that the courts are clogged with dockets, and this is one form of alternate dispute resolution which will ease the burden of the courts. And the number of cases, of course, we are still struggling with the areas in this court, in our legal system, but notwithstanding that, we don't know the lakhs of cases which have been settled through mediation only in Delhi, and if we take the figures of all India, it may be much, much more. The burden of the courts would have been much more than what it is today. And as we are progressing towards the success of this mediation, and mediation is becoming really popular, I think the burden of the courts is going to be reduced in future, which we are looking forward to. I say, even in the context of arbitration, that of course I would not say that it is lessening the burden of arbitration, but in fact it is proving to be more potent weapon, and that is my hypothesis and my belief, that it is becoming more potent weapon to salvage in the situation in which this arbitration is today. Arbitration was conceived as the alternate dispute resolution system, which would be more speedy and which would be cost effective. Over a period of time, we have realized that has not been happening. But in order to popularize arbitration more, all institutions, arbitral institutions, have also understood the importance of mediation, and that is why this Med has started. Why even mediation is introduced in arbitration shows the significance of mediation as far as the dispute resolution mechanism is concerned. And it is because of this reason mediation which is gaining popularity. Initially, again, when it started here also, we thought, and in many other countries as well, that as far as mediation is concerned, it was good for family disputes, it may be good for the matrimonial disputes, etc., and maybe other small kinds of disputes. Over a period of time, it was realized, no, it is very good for even settling the commercial disputes and international commercial disputes as well. That's the reason for last number of years now, when it comes to settling the international commercial disputes, which are becoming more and more complex, that the mediation is resorted to. I don't know what's the reason. I'm giving you one interesting figure or a statement or a news, which may not be good for me personally, that in last 4 months or 5 months, my 4 international arbitrations which were going on have been settled. Maybe lost to me personally, but it shows that the parties want to settle the disputes through mediation. And another step which is now mediation is taking is that it is going into some sectors which were hitherto unknown or known as the sectors where mediation may not be possible. Tax disputes, for example. Nobody can today think that a tax dispute where there is a dispute between the revenue and the assessee can be settled through mediation. May not be in that sense, but yes, initially, if it is a dispute between a public sector undertaking or some semi-governmental body and the government, that is tax department, it is possible. And I think today people may think, and even the government may think, that it may not be possible. That time will come and show that it is very much possible. And time doesn't permit, but I have my own experience. I have gone through that, and I can say so with certainty. Insolvency is now, to which I come to, is another such field. Till few years ago, it was thought that insolvency is one aspect, and there were so many complex issues which arise while carrying out the CIRP, which we call resolution process, etc., the plan which is to be submitted. It may not be possible. It is now realized that rather, if you go through the insolvency process, and those who are familiar with insolvency law know that at many steps, it is the mediation which is more fruitful rather than deciding those cases or those aspects by either the committee of creditors or by the IPs, insolvency professionals who are appointed, because in whatever way they decide, the matter would go up to the Supreme Court. Although it has to be a collaborative effort, and why not through mediation? It is in this process, as I would not repeat that what Mr. Sumant Batra has already said, how ILA was conceptualized and was formed, and the progress which it has made in last 2.5 years. But then we know, and we have come to know, and we have seen many conferences, international conferences on insolvency, which I have attended, many institutions, including the courts, etc. Everybody is today talking about mediation in insolvency. And they think that insolvency is and it is even in SICC, of which I am international judge. Every conference which we have, this is the hot topic of discussion. So therefore, in that context, as Mr. Sumant Batra has already informed you, we thought that, look, there is literature, people are writing about it, it is becoming relevant, but why not have all this wisdom in one place? So this is, of course, I must give credit to Sumant. It was his idea. Thereafter, it became a collaborative effort that we chose the persons who can write on this, either those who are good in mediation or those who are good in insolvency, or there are many, Mr. Chandok sitting here, who is good in both. So we requested those persons from abroad and within India. We have Mr. J.P. Singh sitting here, Mr. Chandok, Iram Mazid, who have all contributed. I think Madhvi Diwan has also written one, has contributed an essay. So it talks about in length and breadth various different aspects of mediation in insolvency. And let me tell you, even for mediation world, those who are doing mediation, when, of course, the general principles or the procedure which is to be followed and what is to be done by a mediator is known. But when it comes to specific field, there are certain nuances which are to be kept in mind. And this book is going to be very helpful in that sense. That is my belief. So with this, I thank everybody. I profusely thank all the persons sitting on the dais. Justice Suryakant has graciously contributed. He has written forward to this book. Justice Manmohan, Chief Justice, when I requested him that can we have the function here, very graciously and immediately agreed to that and said that you are most welcome. When I requested Attorney General to be here at this moment, he said that when you say so, I will not say no, and that is the affinity which we have, and so was Amitabh Kant. So thank you very much, everybody, and I think you are going to really relish reading of this book. Thank you very much.
Thank you, Justice Sikri, for that insightful address. I would now like to request Mr. Amitabh Kant to please come and address the audience.
Honorable Justice Surya Kant, Judge of the Supreme Court of India, Honorable Justice Manmohan, the Chief Justice of the High Court of Delhi, the distinguished Attorney General of India, Honorable Mr. Venkat Ramani, the multifaceted Justice Sikri, who's been a judge, writer, editor, great speaker, many things rolled into one. Mr. Sumant Batra, the co-editor of this book. Mr. Sumit Malik, the director, EBC Group of Companies. Distinguished guests, ladies and gentlemen. The ambition of India is to be a Viksit Bharat, a developed nation, by 2047. This implies that India's GDP has to grow from roughly about 3.7 trillion to about 40 trillion by 2047. And this implies that your GDP has to grow by almost 10 times, your per capita income has to grow 9 times, your manufacturing has to grow about 18 times. And this is not possible without speedy resolution of commercial cases and without mediation being a very inherent part of insolvency. This volume of mediation in insolvency, a global perspective, represents a very significant contribution to the evolving field of insolvency law and dispute resolution. Particularly in India, where the Insolvency and Bankruptcy Code has ushered in very transformative changes in our financial ecosystem. The IBC has marked a very significant shift in India's approach to financial distress. Once India was characterized by the notion that India had transitioned from socialism without an entry to capitalism without an exit. This paradigm shifted with the introduction of the IBC, which provided a much-needed mechanism to address insolvency issues in a time-bound and efficient manner. The IBC has played a transformative role in the Indian economy. At the time of its enactment, many of you would recall, we were dealing with a twin balance sheet crisis where non-performing assets were hovering close to around 12%. This resulted in the choking of fresh credit, which is the economy stalling economic growth. The IBC emerged as a lighthouse of a new era, ushering in what Justice Nariman had eloquently paraphrased from John Milton as a defaulter's paradise lost. It engendered a culture of corporate accountability and credit discipline. A behavioral shift occurred where borrowers realized that they needed to repay their debts. NPAs are now at a historic low, bank balance sheets are robust, credit is growing at a healthy clip. The IBC has so far been successful because the entire ecosystem and the institutional infrastructure came together and played their part. However, as we look at 2024, we must acknowledge some major concerns regarding the present functioning of the IBC, indicating a need for a second generation of reforms. Analysis of IBBI's own data shows that insolvency resolution at the National Company Law Tribunal averaged 716 days in the last fiscal year, up from 654 days in 2022-23. More concerning is the average time taken for the admission of cases, which stood at 468 days in financial year 21 and increased to 650 days in financial year 2022. Recovery from defaulters under the Insolvency and Bankruptcy Code has actually decreased in 23-24 from the previous year. The rate of recovery fell to 27% of the creditors' admitted claims in 2023-24 from 36% in the previous year. Ladies and gentlemen, the creditors are applying for admission under IBC more than 2 years after the account has been NPA. Delay in filing applications is leading to a loss of value for the asset. The IBBI studies show that about 50% of value is eroded before the companies are admitted to IBC. Therefore, it is necessary that the creditor should apply for admission as early as possible. But as we all know, there is an inverse relationship between time and value, and accordingly, the delays are depressing the values recovered. And to my mind, for maximizing the values of a debtor's assets, mediation will have to play a critical and a very significant